So I've been asked to present in relation to the fees bylaws that you're going to be looking at, the amendments to the bylaws. So I think it would help probably to start a little bit in talking about the context for the work that the decision that you're going to be making in terms of thinking about the regulatory framework for a health college like this college. And the regulatory framework, of course, is that because I know council is aware of the importance of the issues that you're now dealing with respect to the proposed increases, but I do think it's helpful to step back a little bit and talk about the framework for self-regulation. So essentially, self-regulation is a choice that government makes. And we really don't have true self-regulation in Canada anymore. We have modified self-regulation or even co-regulation with government. The Constitution of Canada provides that the regulation of professionals is within the provincial government jurisdiction, not the federal government. So that's why the rules are a little bit different from all the provinces. But the provincial governments have choices in terms of how they decide to regulate a trade or an industry or profession. So they can decide to not regulate it at all. And we see examples of that would be midwives in Ontario prior to 1993. They practiced here, but they were not regulated at all. And so they were not under the Health Disciplines Act or the Regulated Health Professions Act till 1993. And so if something went wrong with a home birth, that person's only recourse, for example, was to a civil lawsuit. And there are still a number of other professions in Ontario that are not regulated. Another choice that government can make is to simply rely on consumer protection law. So for example, if you buy an expensive piece of furniture and it falls apart, there's no regulator to complain to. You just have the Consumer Protection Act to deal with to help you get some compensation. Another choice that government makes is to regulate the profession itself directly. And we see that in some examples. Teachers in New Brunswick or BC, BC teachers used to have self-regulation, but that college existed from 1987 to about 2011, and then was replaced by the teacher regulation branch within the BC Ministry of Education when that government agency determined in its view that the regulator was not acting in the public interest. So government can also choose self-regulation, but even within that, there are choices. So for example, the Architects Act, for example, just deals with one profession, whereas the Regulated Health Professions Act was a choice that the ministry made in terms of an umbrella statute to regulate a number of professions at the same time. So even within modified self-regulation, there are choices that government can make. So what is self-regulation? Certainly hundreds of years ago, it was true self-regulation with entities like medical guilds or legal guilds, where the governing body was made up solely of members of those professions. But it's essentially regulation now, where at least the majority of the governing body is made up of members of the profession. Self-regulation also involves the profession being consulted on regulation. So where there are new standards, bylaws, or regulations, those are circulated to the profession for comment. It also involves the profession making and enforcing the rules through the regulatory body. And the profession also pays for regulation. And this may be a primary factor why governments choose self-regulation, why they choose that model. So what are the benefits of self-regulation? So arguably, self-regulation, with self-regulation, there's a certain amount of status associated with being a member of a regulated profession. There's also a protected title that only members of that particular profession can use. And essentially, there's a monopoly on the practice of the profession to some extent. And I do recognize that health professionals who can bill patients privately arguably are able to reap more financial benefits than those who perhaps work in the public hospital settings. But the rationales about the benefits of self-regulation apply to all professions, regardless of how they're compensated. But when government chooses to grant the privilege of self-regulation to a profession, and we know from the Supreme Court of Canada that the court views self-regulation as a privilege and not a right, the government does that as part of a social contract, if you will. So essentially, the quid pro quo for the government allowing a profession to govern itself is an expectation that the college will regulate members in the public interest and not in the interests of the profession. So as I mentioned, we don't have true self-regulation anymore in Canada or really anywhere in the world. We know that because there are public members on council, because government approves the major provisions in the statute, in the RHPA, and has to approve your regulations as well. We also know that the government can change the RHPA itself unilaterally, and it often does, for example, in relation to the sexual abuse provisions in the RHPA. RHPA regulators are also required to report to the Minister of Health on your activities, and there's external review of your activities as well, such as from the Fairness Commissioner over registration practices, the Health Professions Appeal and Review Board over both registration and complaints, the Divisional Court over discipline and fitness to practice, and the Ministry of Health, of course, including such recent initiatives like the College Performance Measurement Framework that you have to do every year. And the Ontario Ministry of Health is quite involved in health regulators' work, certainly in this province compared to some others, but the government's entitled to do that, and they can be as involved as they want to. And we see that they become more interventionist when they think that something is going wrong at a college. And by wrong, I mean when they see that the practices that are seen to not be promoting the public interest and instead are really promoting the profession's interest. So self-regulation is not guaranteed and in fact is ended in most other countries. But in order to keep it, if you think it's worth keeping, the college has to honor that social contract and put the public interest above all else, including the profession's interest. So while the college is made up of council, committees, and the registrar and staff, it's the council that is primarily responsible for strategic oversight, risk management, and leading the college. By doing your work, of course, with integrity, diligence, asking the right questions, and relying on expertise, like that of Blair Mackenzie, when you need it. So council's oversight and risk management work focuses primarily on risk to the public from registrants, on reputational risk to the organization itself, and on financial risk. So as the board of directors of the organization, the council is ultimately responsible for the college's financial stability and indeed its viability. So the briefing note relating to the fee increase starts at page 77 of the council's material, and certainly as your auditor noted, your current financial situation is not sustainable. And so the briefing note contains a great deal of material. I'm not going to read it. I assume that you've all read it, but you've seen that such pieces of information like the fact that you have one of the lowest fees of all the RHPA colleges and that your fees haven't increased for 14 years. So essentially, if you think that self-regulation is worth maintaining, then a fee increase is necessary at this point. So now I'm going to start actually walking you through the bylaw amendments. And so if you've got your council package open, this is starting at page 83 of the actual wording. And so, of course, Blair is the expert with respect to the specific elements of the college's financial position, working with the Finance and Audit Committee. And I'm merely assisting with respect to the wording of the amendments to achieve the outcome that the Finance and Audit Committee and management has recommended. So at page 83, we can see at section 26.1 of the bylaws that the proposal is to increase the initial application fee by $25. So that on September 1st, 2025, it would become $125. The registration and annual fees, as Blair said, are proposed to be increased over 3 years. And the difference between those two fees is that the registration fee is paid when an applicant first applies to the college, or in some instances has resigned and reapplied if it's been after 5 years, as compared to an annual fee, which is payable by registrants who are already members of the college every year to maintain their registration. So just to be clear, though, a person does not pay both a registration fee and an annual fee in the same year. Once a person becomes a member of the college, a registrant of the college, they pay an annual fee. That said, the amounts of the fee are essentially the same. So it makes sense to sort of look at the annual fees rather than the registration fees because they're really duplicative. They're the exact same amount. So at page 84 of the package, you can see that the current annual fee is $470. And the proposal in the material in terms of the edits to the bylaws is to increase that starting September 1st to $545. Starting on September 1st, 2026, the wording would take it up to $615, the annual fees. Starting on September 1st, 2027, the proposal would take it up to $643. So this is really just doing the things that Blair has talked about, which is the recommendation from the Finance and Audit Committee. And then the proposal, and this is in section 26.5.3 of the bylaws, is what Blair referred to as the COLA. And I know that we're back on the recording, so I'll take this opportunity to say that that's a cost of living adjustment. So anybody who's listening, just looking at the two recordings, will see that that's what we're talking about. So essentially, after those three relatively larger increases to begin with, the bylaws would then include a provision that would allow council each year to increase the fees by the amount of the consumer price index increase from the previous year, rounded up to the nearest dollar. And that would be done annually unless council determined that it's not necessary. So it's not automatic. Council would still put its mind to it. If it felt that it wasn't necessary, it would make a decision to not do that. And the draft language that's in your original package refers to an amount equal to the Ontario Consumer Price Index, but the actual proposal from the management group is to change that slightly to say that it would be up to, but not more than, an amount, the annual increase in the Ontario Consumer Price Index, so that it's not all or nothing. It's not either no increase or the amount of the consumer price increase in Ontario. It could be something less than that. So we're just going to change that slightly, but we didn't have time to change the actual wording in the material. And so that built-in cost of living increase is quite common in Regulated Health Professions Act colleges. In the bylaws of other colleges, it's been there for quite some time at other colleges. And that will help you to make sure that you don't get into financial difficulty in the future, but registrants can still easily calculate what their annual fee will be the next year, because all of us sort of pay attention to what the cost of living increase is doing. So I'm going to come back to the proposed revision in section 26.6.1 in a minute. That's a different type of change, but I first want to talk about application fees for people who were previously registrants who resigned and then reapply. So this is at page 85 of your package. This is section 26.13. And you can see that ex-registrants who've been away from practice for 5 years or more, the application fee to re-register is proposed to increase by $25 to $125. And certainly in my view, that makes sense because there's a lot of administrative work involved in registering somebody who's been absent from the profession for that long. If you look above that in 26.12, there's been no proposal to make an application fee for somebody who's been resigned and then reapplies less than 5 years after resigning. So they do not pay an application fee to re-register. And while the same amount of resources are needed at the college to re-register those people, and so arguably an application fee for them would also be perfectly reasonable, the college or certainly management has made a decision to not charge an application fee in those circumstances, because often those instances arise in the case of somebody who has resigned, perhaps to take a parental leave. And so balancing the impact of the application fee as against the resources of the college, it's a reasonable decision to not charge those people a fee. And perhaps in any future iteration of your registration regulation, there could be thought put to having an inactive category so that those people who are not going to be practicing for a year or two don't have to resign and can simply move to an inactive category with a lower fee. So essentially that's the proposal with respect to 26.1.3. So the application fee for ex-registrants who've been out of practice for 5 years or more will increase by $25. So at the very bottom of page 85 of your material and then over to the top of page 86, you'll see that management group has proposed that the application fee for someone to apply for reinstatement after they've been revoked or suspended by the discipline committee is proposed to double from $100 to $200. So it's really important to keep in mind that these are primarily registrants who've been revoked by the discipline committee for professional misconduct. So there was already a finding of professional misconduct that warranted revocation of these applicants. And while the application fee also technically applies to someone who's been suspended by the discipline committee, in my over 30 years of doing this work, I've never seen a reinstatement application for someone who's merely been suspended, because usually always the discipline committee order will say when the suspension ends. So usually the suspension just runs its course and the person re-registers. That said, the RHPA is quite clear, the code is clear that if somebody has been revoked, they don't get to come in sort of back through the front door through the registration. They have to apply for a reinstatement hearing. And those reinstatement hearings are very expensive. The college is required to hold a hearing before a panel of the committee. There's going to be lawyers there, there's court reporters, there's per diems. So there are expensive hearings, and the code does not allow for the college to get costs at the end of the hearing, even if the applicant is not successful at reinstating. So that, again, that's something that you have no authority over, but it is reasonable, even though a doubling of a fee is quite expensive. This is a fairly rare instance to happen, but again, the reinstatements are very expensive. And while this technically would also apply to fitness to practice decisions, again, rarely do those actually result in revocation. The vast majority of cases for fitness to practice are terms, conditions, limitations are imposed. So the person simply has to do something such as get medical treatment, and then they get back to practice. So this is back to page 84 now of the material, and this is section 26.6.1. This would be a new section of the bylaws, a new addition, but it does exist at a number of other RHPA colleges and has done so for some time. And so what it would do is add any outstanding amounts ordered by a committee of the college. And again, the most common one is going to be the discipline committee, and such as costs of a discipline hearing, including legal costs and prosecution costs. These would be added to the annual fee. So if a registrant didn't pay the discipline hearing costs that were outstanding, the registrant could be suspended under the code for non-payment of fees. So this is really helpful, because if the discipline committee orders a member who is found guilty of misconduct to pay some of the costs of the discipline hearing, without a provision like section 26.6.1, the member could simply choose to not pay the costs and take their chances that the college won't try to recover the costs in court, such as by trying to get a lien on any property they own. And of course, if the college has to go to court to try to recover costs, that itself costs money. So the college has to pay money to collect money that's owing from registrants. So without this section, the rest of the profession really bears the expense of the entire discipline hearing, despite the costs award being ordered by the discipline committee. It's also important to keep in mind that a costs award made by a discipline committee, they're never for the entire amount that the hearing cost. At the very most, they are 2/3 of the hearing of the actual cost in a contested hearing, and the courts, the divisional court, has essentially set that limit through its case law. So this proposal would give the college a very helpful tool to collect those costs from members who've already been found guilty of professional misconduct, and if they don't pay, then they will be suspended until they do. And so some of the proposed red line edits in your material are simply updating old references to regulation numbers that are no longer accurate, such as at page 85. I've added headings to try to make the fees bylaw a little bit more easier to access for people reading it. At section 26.13, just tidied up the language to help distinguish between registrants who resigned for something like a parental leave and coming back, versus, because the regulation uses the term re-registration as compared to the term reinstatement, which is used under section 72 of the code for somebody who was actually revoked. And so I also propose that the addition of headings, but those are really, of course, not substantive changes, and there were no proposed changes to the health profession corporation fees. And with that, I will turn it over to the chair.